Good day. I'm Vannessa Nicholas, Head of Estates Administration at Appleton Fiduciary Services. Today we're discussing the often misunderstood topic of living wills. Picture this. You're in a medical emergency, unable to communicate your wishes. Who decides what happens next? Your wishes and values matter, and that is where living wills come into play. Whilst a last will and testament sets out your wishes and deals with how your assets are to be distributed after you die, a living will expresses your wishes for your medical care whilst you're still alive, ensuring your wishes are followed even if you're unable to speak. So a living will can speak for you when you cannot speak for yourself. But what exactly is a living will? It's a legal document that allows you to outline your preferences for medical care. It gives instructions whether you want life-sustaining treatment or not, and instructions for not being kept alive through life support or other artificial medical intervention when there's no hope of recovery and death is inevitable. For example, someone in a coma, unconscious or terminally ill, in cases where you are unable to communicate due to illness or incapacity. Wills are not just for the elderly or the sick. They are for everyone, because accidents and health issues can happen to anyone at any age. It is about taking control of your future, no matter what the future holds. So by having a living will, you're not only making sure that your wishes are respected, but also easing the burden on your loved ones during the tough times. This helps reduce the financial burden of advanced life support when there's no prospect of recovery. So we would recommend that you let your family know that you have a living will and what your wishes are. This will avoid any disagreement between family members and vital time wasting when important decisions need to be made by your doctor in regard to treatment. An interesting question that is often asked is whether living wills are recognized in South African law. Living wills are not recognized in South African statutory law, although anyone over the age of 18 who is of sound mind can have a living will written. However, our law does in fact recognize each person's right to accept and decline treatment. The South African Constitution states that everyone has the right to bodily and psychological integrity, which includes control over one's own body. The hospital's doctors will request a next of kin to sign a do not resuscitate document, even if there's a living will. So by having a living will, the next of kin adheres to the wishes of the individual. We at Appleton Fiduciary Services prepare a standard living will with each of the last will and testaments we draft for clients. So remember, copies of your living will should be made available to your spouse, children, as well as your general practitioner, so that they are aware of your wishes. Should you be admitted to hospital, a copy of your living will should also be presented to the hospital. In summary, a living will is more than just a legal document. It's about your values, your beliefs, and ensuring that your wishes are honored with dignity and respect, and your voice is heard even when you cannot speak.